Hi, my name is Eddie Stevens, and I am the Director for Legal Education for the Center for Child Counseling. We have been producing a monthly family law CLE since August, and they are really cool. The November 15th edition is a 1-hour CLE that features Ron Kaufffman, Kelly Albanese, and a very special interview with family law legend Melinda GAMOT by CARYN Stevens. We think once you see the production of this CLE, you'll agree there simply is no competition. If you would like a copy of the materials for this episode, go to this website and download the PDF. If you would like to get CLE credit, take a look at the description in the YouTube comments for the course number. We hope you enjoy this episode.
Welcome to this month's edition of Stevens Squibs, brought to you by the Center for Child Counseling. It's time to gather around the proverbial fire and discuss Florida family law cases and more. Please welcome your host, Eddie Stevens.
Hello and welcome to the November 15th episode of Stevens Squibs Monthly Family Law Case Law. This is our fourth installment, and I can't believe we're already 1/3 of the way through our first year. With me today, CARYN Stevens and GINA SZAPUCKI. Hey guys, how you doing?
Hi, happy November. Can't believe the year's almost over, but let's be real, we're glad it's almost over this year.
We are still here.
And it has been a great month. And earlier this month, if you missed it, the Center for Child Counseling premiered a 4.5-hour CLE. This was our second annual mental health summit, and that is available for on-demand viewing. 4.5 hours of great CLE, plus we honor the Florida Bar President, Dory Foster Morales, and we also acknowledge Laura Davis Smith for their contributions for creating a trauma-informed legal community. So today we have a great show. We're going to go through all the cases from September. In addition, we have Kelly Albanese, who will have a board cert tip. Ron Kaufffman, who litigated one of the cases and did the appeal for one of the cases we are talking about, is going to join us. And finally, CARYN Stevens does her first legend interview with one of my favorites, Melinda GAMOT. So we hope we have a very informative, interesting, and fun CLE for you today. We're going to start off. You should have the materials. It was not a very prolific month for the Florida appellate courts, but they did put out a few opinions. And the first one I'm going to talk about is Tordini. It's an alimony case out of the 5th DCA. And Tordini was kind of interesting because at the end of the day, the court fashioned an alimony award. It didn't quite meet the wife's needs, and it didn't take up all of the husband's surplus. So it appears the wife was shortchanged, and there was really no explanation by the trial court as to how it arrived at its number. The Tordini court went straight to Canacaris and cited, well, there's got to be, you can't go from misfortune to prosperity, you can't go from prosperity to misfortune. There has to be some reason in viewing the totality of the circumstances, and neither party should be shortchanged. Based upon the trial court's unchallenged findings, that she had a need and he had a surplus, the alimony award falls short of meeting the former wife's basic monthly expenses without explanation, and it left the former husband with a pretty large surplus, all without explanation on the record. That alimony amount was reversed. Going on to our second case, I think that's an alimony case, and it dealt with some findings. Actually, it's a fee case that dealt with some findings of income. Court denied attorney's fees for the wife basically saying, well, you came up with the money during the case and now you're asking for it afterwards, and you were able to pay your attorney, so I'm going to deny your fees. That was appealed, and they basically argued you need to go through the findings of the wife's needs in this case and the husband's ability, and those comments were not really enough to dispute that. There were also some errors the court made, like the court took the wife's income that already included her alimony, added it to it, deducted the alimony from the husband's income when it was already deducted in the financial affidavit. And he also deducted the child support the husband paid and added it to the wife's income. And the court made it very clear child support is never considered a party's income. So that was the Gonzalez-Reyes case.
So the next case is Root versus Feinstein, and this is a real short opinion here out of the fourth. And this involved the wife, Miss Root, who had accessed her husband's emails during the pendency of this, I think it was an enforcement or modification proceeding. And so she accessed his emails, and she also had a request pending for fees. And when the court denied her fee claim, the court said that because of her bad conduct, they were denying her fees. So the fees were directly denied specifically because of the wife's misconduct in accessing her husband's private emails. And they blamed it, and they said the fees denial was a sanction against the wife for her conduct. And the fourth said, you can't do that. You have to make express findings on what part is based upon the misconduct, the bad behaviors, and what part of it is based upon some other reason for the denial. So it was reversed and remanded back, and the lower court down in Broward County was ordered to parse out what part of it are you blaming on her email misconduct shenanigans, and what part was a denial based upon not needing the fees or prevailing party provision or something like that.
And now we're going to go into the enforcement arena. Case number 4, Webb v. Webb, in your materials. It's out of the second DCA. This was an interesting case where the husband challenged the enforcement of an equalizing payment. And he took the novel argument that in the settlement agreement, they said he was going to make the equalizing agreement, and therefore there's a 5-year statute of limitation. Well, there's also a 20-year statute of limitation in enforcing a judgment, and the appellate court was here faced with which one do you apply? And apparently there's no case in Florida that decides this issue. So this is kind of a new case of first impression. The appellate court specifically says, although no Florida court has made a definitive pronouncement on this precise point, our case law seems to have leaned in the direction that the circuit court's ruling, meaning the judgment, should be the basis. In other words, you get the 20 years instead of the 5. And there's an interesting discussion between merging and incorporating and the legal effect that has. If you merge an agreement into a final judgment, the agreement loses its own legal force. But really the issue in Webb was the 5 versus the 20 years. So be mindful, you got 20 years to enforce an equitable distribution, equalizing payment. So let me take you down to injunctions. Walker v. Harley Anderson. If you recall, in a previous episode, we talked about a Supreme Court case in the issue of authentication of text messages. And this case came up in the 4th in the Walker v. Harley Anderson case, where one family member said to a separate family member, there were some implications that violence was coming, and text messages were sent and they were received, and these messages were very, very disturbing. Problem is, no one could tell exactly where the text messages came from. The petitioner testified, well, there was no one else that would send me these except for this person that's threatening us. That is not enough. The appellate court went into a little detail, in a little more than the Supreme Court did recently, and teaches us Section 90.901 Florida statutes, which is the authentication evidence code, provides that authentication or identification of evidence is required as a condition precedent to its admissibility. The requirements of this section are satisfied by evidence sufficient to support a finding that the matter in question is what it claims to be. So in determining that, the court must evaluate each instance on its own merit. So it's kind of a case-by-case analysis. There is no specific list for requirements in making this determination of authentication. Evidence may be authenticated by appearance, content, substance, internal patterns, or other distinctive characteristics taken in conjunction with the circumstances. In addition, the evidence may be authenticated either by using extrinsic evidence or self-authentication. So those are all the ways to authenticate a matter. Testimony that a person received a text or email from another person is not sufficient. It comes right out and holds that it is not sufficient by itself to authenticate the identity of the sender. Circumstances recognized as sufficient to meet the test of authenticity include when a letter is written disclosing information which is likely known only to the purported author. So if the author says you have a mole on your private area, no one else would know it, that may be a way to circumstantially link it up. But it's really important that you look at that phone number, where it comes from, and you have some evidence matching up that phone number with the sender. That's the best way to do it. And I think that's a pretty good practice tip. Karen, you want to take us on with case number 6?
Sure. We have another case in the injunction arena this time, and this was actually an opinion that replaced another opinion some months ago. And this is the Pauley versus Marie case. Mr. Pauley is the appellant. He was the respondent to a domestic violence injunction that was filed by his then girlfriend, Miss Marie. Mr. Pauley is actually sitting in prison, serving a 40-year sentence right now for attempted first-degree murder and aggravated assault. He also appealed that case. There's a Pauley versus state criminal opinion as well. But nonetheless, Mr. Pauley, when the court entered a permanent injunction against him and protected Miss Marie, the petitioner, Miss Marie, at the time alleged in her petition that she lived with Mr. Pauley, thus giving rise to the domestic violence injunction standard. And Mr. Pauley now, some years later, is claiming that he was not living with Miss Marie at the time that she had filed the petition for injunction for protection, and was claiming that she had committed fraud on the court. Be it as it may, whether they did or did not live together, what this case teaches us is that poor Mr. Pauley spent too much time waiting to bring this to the court's attention, because what he was trying to do was a 1540 motion to set aside the judgment based on fraud. And the appellate court down in the third said to him, you waited too long, dude. So he had filed it more than 1 year since the entry of the final injunction order. So this just reaffirmed 1540. It's a 1-year term based on fraud. So yeah, it's unfortunate. I guess he was focused a lot of his free time on his criminal appeal and had lost focus on his domestic violence appeal while he was sitting in the prison. But nonetheless, so 1540, you got 1 year to set aside a judgment based on fraud.
And now we jump to procedure. Karen, you got the first
Yes.
case.
I got the first procedure case too. So this is the Murphy versus Collins case, and this is from down in Monroe County in the Keys. And I discussed this case a couple of months ago, a similar fact pattern involving the same attorney. And if you'll recall, I think it was probably back in episode 2 at the time that we did. The judge down in Monroe County had made some comments about the attorney in front of her. And the comments were made in the other case, which is the one that we briefed up to 2 or 3 episodes ago in our program here. And the judge had made comments that lawyer wasted the court's time and she didn't want to give him any special permissions anymore, and that he drained her, judicial assistant's time and he played games. So those comments were made in the other case, and they had filed a writ of prohibition, and we discussed that a couple episodes ago. This case involves that same attorney, but now with a different client. And what happened in this case, it was a paternity action. There was a motion to dismiss based on a non-convenient forum because the mother and the child now lived in Pennsylvania, I think it was, and the dad had stayed down in Monroe County, and the mom had filed a motion to dismiss because dad filed a paternity action in Florida down in Monroe. And to make a really crazy, long, convoluted story short, what the premise of this is that the judge entered some oral pronouncements at the conclusion of the motion to dismiss hearing. And she made certain representations, and she ordered the mother's attorney to send in a proposed order. And like we've all experienced on occasion when you have a difficult opposing counsel for mom, counsel for dad, they could not possibly agree to a form of an order. She had asked for one proposed order to be sent in. So when they couldn't agree, mom's counsel sent in his proposed order with a copy of the pronouncements on the transcript to the judge. And at the same time, the other attorney had filed a writ of prohibition or they had filed a motion for disqualification of the judge, which was denied based upon the comments that judge made about the other attorney in the other case. That was denied. They took up a writ of prohibition to the appellate court. And while that was pending, one day after they filed that, the judge now enters the order. And not only did she not enter any form of the proposed order that the attorney had sent her, she went ahead and just sort of redrafted something entirely different and did more than just ministerial actions. And so the problem is because the writ was pending and she did an order that completely conflicted with her oral pronouncements, the appellate court said, no, you can't do that. They reversed it and sent it back down for the new judge to hear it and enter a proper order. So what this case teaches us is that while there's a pending writ or a motion for disqualification pending, the judge for which that action's pending against, they have the right to do some real basic tasks and ministerial things, sign an order, whatever. The problem with this case, it was way more outside the scope of just an order because she went and redid everything and it didn't follow the oral pronouncements. So the appellate court said that was a big no-no and the court committed error.
Wow, that's a lot.
That was the short version of that case.
The next procedural case is Murphy v. Hutchins, and this is a very, very short opinion out of the Fifth, which deals with a mother who appealed an order adopting a report and recommendations from a general magistrate. And in her appeal, she made a bunch of allegations. However, the appellate court affirmed the order and stated that because the mom did not file the proper exceptions within the deadline, that the appellate court is now restricted to basing their decision solely on the errors of the face of the order. And here, again, the mom did not file any exceptions. So this case is a great reminder to make sure that we calendar all our deadlines once an order comes out so we can preserve all the issues that we can potentially appeal a case on.
All right, now with me today is a very special guest. He was involved in the Frank v. Frank appeal that we're talking about. Ladies and gentlemen, board certified family law attorney, RON KAUFFMAN. Ron, are you with us?
Good morning, Eddie. Good to see you and hear from you. In this quarantine, we don't get to have all the social contacts that you and I are used to at our regular meetings, and it's good to see you and hear from you.
It's great to see you, Ron, and thank you for joining me on my monthly CLE, where we talk about all the cases that came out, and a really interesting one came out in August, Frank v. Frank. And you actually reversed a judgment, but you weren't representing a party. You were representing a non-party. Can you tell us about that?
Sure. So in this particular appeal, a husband and wife were getting divorced here in Miami, but they aren't originally from Miami. They were from Missouri. And the husband's mother, the mother-in-law, essentially loaned them a lot of money in Missouri so that they could start their life there, help them to purchase a home, renovate it, and even maintain it. But then they moved from Missouri down to Miami and abandoned the home and never paid back the Bank of America loan, the taxes, or the mom. And so the mom filed the lawsuit in Missouri, where the loan originated and where everyone was living. And they actually litigated it. Everyone had attorneys, everyone testified, and they had a final judgment issued in the circuit court in St. Louis. And my client prevailed. So the husband and wife moved to Miami and bought more property and developed, their life here. But then things soured and they filed for divorce. And we were concerned about collecting on a foreign judgment. So we were retained to collect on that foreign judgment and intervened in the divorce. And that's where things kind of took a turn because, neither party was particularly happy about having their equitable distribution impacted by a foreign judgment, a very large one.
And in this case, the trial court in Florida actually made some modifications to that foreign judgment.
That's right. And so that led to the appeal, and that was a big sore point at trial, that they started attacking the foundations of the final judgment in Missouri. And the way it works is, if you have a foreign final judgment and it's been fully litigated according to our Constitution with due process concerns and fair notice, once you record it in the public records in Florida, for all intents and purposes, it becomes a Florida final judgment. And unlike the divorce final judgments that you and I deal with all the time, when you are sued and get a final judgment in a civil action for damages, they're not always modifiable. In fact, they're rarely modifiable. They become what we call res judicata. And at trial, they started attacking the underlying final judgment in Missouri, and our circuit court judge here decided he was not only going to modify it, he was going to reduce the full damages and not make both of the husband and wife jointly and severally liable. So once the trial judge did that, it was our argument that he made two fundamental errors. The first was a constitutional one, which is what we call the full faith and credit clause. And that basically protects a final judgment from another state from being attacked in Florida or any other state. And that was a big problem in family law cases where during for example, with grandparent visitation, it was a big problem because Florida does not recognize grandparent visitation, but a lot of states do. And grandparents would come down to Florida and try to enforce their grandparent visitation rights. And Florida courts were saying, no, you can't. And then a few years ago, the Florida Supreme Court said, no. We have this Constitution. We have the full faith and credit clause. And that means you have to give full faith and credit to foreign final judgments, even if it violates our own public policy. So that's what we argued at the trial level. And we also argued something else. Florida has a simplified version to register foreign final judgments. It's the Florida Enforcement of Foreign Judgment Act, and it makes it very simple to record and enforce a foreign judgment. And so under both those grounds and the constitutional grounds, we asked the judge to rehear what he had done. And then when he didn't, we took it up to the Third District Court of Appeal, which reversed ultimately.
Well, Ron, I think you did a great job for your client. This is a unique case in that you didn't represent a husband or wife, and got to play with some real neat constitutional issues. So congratulations.
Well, thank you very much, Eddie.
And we certainly appreciate you taking the time to appear on our CLE this month. Thank you very much.
Pleasure to be here. Have a great day.
Thank you, Ron, for that incredible insight. And we have one last case to talk about under procedure, the Vercetti case. And it really holds for something that is kind of important to know. We have Chapter 12 of procedures, and we have Chapter 1. And in the old days, if there was a Chapter 12 that was missing, we would go to Chapter 1, the civil procedure rules. Well, that all changed, I think, in 2017, where the Supreme Court finally authorized family law rules of procedures, which are now independent. It's its own rules, standalone. They do not refer back to the rules of civil procedure at all. How this came up was a motion to transfer venue was denied because it wasn't filed within 60 days. There's a rule 1.061G, which is in the civil rules. It says you have a 60-day time limit, but that rule doesn't exist in Chapter 12 for the family rules. So just a little reminder that when you're looking at family law rules, don't look at Chapter 1.
And now, a discussion of the Florida Bar's disciplinary orders since our last meeting.
We had some very interesting ethical issues. We only lost one lawyer to disbarment this year. I guess this month. I guess that's
this month. Yeah, just this month.
That's better than some previous months. We lost one attorney. It was really not a Florida proceeding. It was reciprocal from Florida, but he apparently misappropriated close to $900,000. So if you get disbarred in New York for misappropriating $900,000, you're probably going to lose your Florida license. Case 2, someone gave up their license in a disciplinary revocation, which is tantamount to disbarment for abandoning client matters, failing to communicate. This guy was only an attorney for 9 years, so sad to see that happen.
A lot of young attorneys again this month, which is sad.
Case number 3, the names are in the materials, but I don't really feel like mentioning them. This attorney has an emergency suspension because failed to respond to an order to show cause from the bar. Bar will escalate its punishment, and if you don't participate, if you don't have an email on file, if you don't respond to them, that is a violation of the rules of professional conduct in itself. Case number 4 I thought was kind of interesting. Attorney lost their license for 3 years, suspended, because they had their name on something called the Criminal Defense League, which was some kind of legal boiler room for criminal matters. But the attorney who was listed as managing attorney had nothing to do with the practice, and basically non-attorneys did it. He also created a company so funds could be transferred from clients to non-lawyers. 3-year suspension. 5, attorney was suspended for 3 years for aggravated felony battery, in a domestic situation. That's not just a black eye that's causing great bodily harm. And he did not notify the Florida bar of that arrest. So that was an aggravating factor. We have another 3-year suspension for an attorney failing to notify his clients that he was suspended. So, those suspensions increase depending on where you're at. Number 7, an attorney was suspended for filing something without independently investigating to determine the validity of the client's claims.
Not just one of them, a lot of them for the same client.
Yeah.
So, and he wasn't verifying the authenticity of her signature. He was just at random filing for this lady.
So, that's a nice little reminder. If you put your signature on a pleading, you're representing that, you have done some due diligence to this, and, be careful. You got to look into these things before you just sign them. Number 8, I found interesting. An attorney represented a husband and wife and slept with the wife and had some business dealings unrelated. That was a 90-day suspension.
Number 9, the guy was suspended for 30 days. He had some 20 grams or less of cocaine, a whole bunch of drug paraphernalia, cannabis.
20 grams of pot. 20 grams of cocaine is different.
Sorry, I read that wrong. You could tell I'm not cool,
That would be,
which is a good thing. I got
you probably would have not gotten into a diversion,
Yeah.
but what is it, two fingers? I don't know. It's been since the 70s. What the heck?
Focus on the facts. Focus on the facts. Should have done better.
Anything else interesting? Oh, 30-day suspension for telling a client to break into a
Yes.
safe to get
I loved
confidential
it.
medical information.
How many times in divorce world have we been asked, like, can I go get? No, you should not be breaking in safes and emails. This is a good one. He told his client.
And it's great precedence because, now we have a Supreme Court precedence that attorneys cannot get away with shenanigans such as that. Case number 11, our last one, is a reprimand. I think it's similar to case number 4, where someone got a 3-year suspension, but apparently not as much harm, and there was no money being shared with other attorneys, but someone trying to help get people out of timeshare contracts. And it was a non-lawyer operation, and this person was publicly reprimanded. So that takes us through our cases and ethics for the day. Now, we have a very special board tip from recently board certified attorney Kelly Albanese.
Stephen Squibs presents this month's board certification tip.
Ladies and gentlemen, I'd like to welcome a very special guest, one of the 4 passers of the most recent board certification test, Kelly Albanese. Kelly, are you with us?
I am.
And congratulations on becoming board certified in this most recent round.
Thank you so much.
It is truly an exciting thing, and to be one of the 4 people that passed is remarkable. So congratulations.
Yeah, very exciting. Thank you again.
Well, I believe the best people to give tips on how to pass this test are the people who just passed. And I thank you for answering my call, and was wondering what tips you can share or what helped you pass this really tough exam.
Absolutely. So I would definitely suggest and advise reading through the Florida Law Weekly collected family law cases for the past 2 years. And, a lot of the cases are dealing with dependency. You can skip over those because that's not on the test. But as for all of the other cases, read them all, highlight them. You will see a pattern of what the courts are getting the appellate courts are having brought in front of them over and over again. And the test, you will see that a lot of the fact patterns come from those cases out of the collected cases. So in January, they release the paper copy for the year before. Go ahead and order that. You don't need the hard copy to start highlighting. Order that and just go through all those cases is a must.
What do you think about how you approach studying the statutes?
That you'll see, again, they refer to certain statutes. I mean, the time sharing, alimony, those ones know like the back of your hand. But I also got through LexisNexis, I don't know the exact off the top of my head, but just it comes with 2 books, and I can send you that information later. But it's just a collection of all of the family law statutes, and just go through that at least once. It'll give you a refresher, and that's pretty helpful as well.
And there were only 4 people that passed this year, and there was a lot of criticism that the test is too hard. I passed back in 2004, and then I was on the committee that wrote and graded the test, and we always thought it was hard but fair. Now that you've studied for it and passed it, what do you think about the exam?
It's hard, but I think it's fair. It took me 3 times, to be honest. So I took it back in 2017. I was close, but just didn't get that, I saw once I reviewed it, because they give you a chance to review your answers, why I had, come short. I couldn't take it in 2018 because I had a baby at the end of February, and the test was 2 weeks later. And then I took it again in 2019, and honestly, it just wasn't smart. I shouldn't have taken it at that time because I was in the middle of moving. My kid's first birthday, just again, bad timing. But this year, I happened to be pregnant. And so I just, from January 1st until I took the test, I made sure I studied at least a couple hours every single day. I maybe took off a day here or there, but that was what my focus was. And I really think that if you just study enough, they're really not trying to trick you on the questions. I don't think, again, after taking it 3 times, it's hard, but they want to make sure that they, are weeding out and, now, you can call yourself, kind of an expert in the field, and they want to make sure that you're qualified to do that because people, already it's only been a couple months. I mean, people really look to you as, being able to help them now that you have this extra level of certification. So
be careful. You also now have an extra layer of liability too.
Exactly.
Even though that has never been an issue in my career. Did you think they tell you what's on the test with the core topics and the sub core topics? Do you think it was true to those areas of law?
Yes, I do. I followed those. And another little tip is I think every single time I took the test, there was one multiple choice question on surrogacy. So just review that statute at least once, know that statute, and I can almost, I can't guarantee, but pretty certain that if you know the statute, you'll be able to get one multiple choice question right.
And during the lunch break, did you talk to anyone about the test?
Nope.
Did you take it by computer or did you do the old blue books?
Definitely computer.
Did you have any issues with the software that they put on your computer?
Never once. Nope.
It's interesting how things changed because in 2004, the minority of the people used their computer and the rest of us did it the old blue book fashion. I'd be interested to see.
I would definitely suggest doing the computer. And even when you do the little class that they offer before the big CLE in January, everybody suggests, you want to type it because if they have trouble reading your handwriting, that could cost you points.
Did you write in a narrative answer or did you give a bullet answer?
I did it in broke it down into paragraphs, dealing with the issue of alimony and then the issue of, if they asked, I think there was something about the Hague, the Hague Convention issue. And I underlined those and then just wrote those out in each. So less of a narrative. It was kind of a narrative when I broke it down. But I definitely made it where they knew what topic I was talking about in each part.
And if you sign up for this test, chances are you're going to fail it. And you were brave enough to tell us about your 2 previous attempts.
Yep.
Were you ever discouraged with this and said, this isn't for me, or?
No, just because I knew the first time it was actually encouraging that I got as close as I did. And it kind of pushed me knowing, okay, this is more doable because everybody has, you so scared because it is so tough. The second time I knew it was there was no chance because I just knew that I didn't prepare enough. And then, if I hadn't passed it this third time, knowing how much time I put into it, and then I really dedicated myself and took every single day to at least, look over something. I probably would have been a little rough if I didn't pass this time because I don't know what I could do different.
So you were pretty happy to get that email?
Yes, very. I read it a few times because I was like, am I reading this right?
Well,
another thing is, not to interrupt, but we all took the bar. And that's what I went back to is what did I do to help pass with that? And I'm very big on, if I write something down, it helps me remember it. So, and not typing, but actually writing pen. So I wrote note cards and then I would keep reviewing those note cards. And that was what I did for the bar as well. So kind of look back at that and think, how did you pass the bar? And kind of go with that same strategy, I think, is a good way to handle it.
writing out longhand works really well for me. Once I do that,
Yeah.
it's pretty much stuck in my head.
Exactly.
Do you have any other tips you have to offer folks that may be thinking about taking the test, maybe people that are scared of taking the test, scared of failing it?
It's give it a try. I mean, the worst that can happen is you fail and you just you can try again. I mean, even just the honor of being allowed, I know people that have applied and haven't even been given the chance to take it. So just being able to, have a peer review and pass all of that to take it is an accomplishment in and of itself, I think. I would definitely suggest go, because the first year I didn't go to the CLE in Orlando. I just got the books. Definitely suggest going to that CLE. Sit in the first 2 rows. They let you, they have those dedicated to the test takers, and just pay attention. You can get the slides afterwards and make sure, the speakers will start to have repetitive things as well that they talk about. And those tend to be things that are brought up on the exam as well. So.
Well, Kelly, congratulations. Your perseverance has paid off. And thank you for sharing your advice with everybody.
Thank you.
We wish you the best of luck.
All right. Thanks.
Thank you, Kelly. And now, with her premier legend interview, we have CARYN Stevens interviewing the great Melinda GAMOT.
Welcome to Stevens Sandbox, a segment where a Florida family law legend steps into the sandbox with Eddie or CARYN Stevens to discuss ethics, professionalism, their career, and staying sane in such a high conflict industry. Are you ready? It's time to step into Stevens Sandbox.
All right, good morning. We're here chatting with Melinda GAMOT, one of the heroes of family law, one of the epic trailblazers of family law. And we're going to be having conversation about some of Melinda's experiences and working in this field for so many years, and tips of the trade, and some other fun conversations. So thank you for joining me, Melinda. I'm so happy to have you.
Well, thank you for inviting me, although I don't think I live up to all the billing, but
it's so nice to have you joining me. So I want to talk to you a little bit about Melinda. So I'm a female attorney, you're a female attorney. And I remember when I was growing up that law was always a kind of a good old boys club. It was the guys group. And I grew up in family lawyers, and that's all I ever saw were men doing law. And when I got into this field, I looked to women like you who had been doing this amongst the guys for so long. So tell me a little bit about what it was like getting into the field of law as a woman, sort of back in the day. That's how we'll call it, okay, for today.
Well, we can call it what it was. It was a really long time ago. It was earlier than back in the day. I mean, a lot, fortunately, has changed in basically a generation. When I was in law school, I think 10% of the law students were women, and it's over 50% now. And even fewer than that that came out of law school actually did any litigation. I'm not smart. I'm just incredibly lucky because I wound up with one of the old, really well-respected, established firms in West Palm Beach when I got out of law school. The old Cohn, Wagner, Nugent, Johnson, Missouri law firm. And that's all they did was litigation, predominantly plaintiff's work, but I got involved in doing a lot of the commercial litigation and the general litigation. And we were kind of inventing it as we would go. I mean, we had cases literally all over the state, and I'd be picking a jury and, Bartow, and the judge didn't know how to deal with us, but it was fun. It was something that really can't be replicated now. It's hard for young lawyers to get the kind of trial experience that I just fell into. So that was a huge break for me.
So when you started your career and there wasn't a lot of female role models, or maybe there was a few or a handful, how did you sort of find your way? Was there a mentor who helped you? Were there mentors, people that you looked up to?
There were some fabulous role models I had to look up. Barbara Pariente was a partner in my firm. I was the second woman to join that firm. She was, an awesome person to be a trailblazer. Rosemary Barquette was another of my big heroes at the time. She went on to be a circuit judge and then a Florida Supreme Court justice. And then she was on the 11th Circuit Court of Appeals, and now she's in The Hague. So those two women really set the stage for my generation. We were a few years back, but they were, 5 or 6 years makes a huge difference at that point. So I had really good footsteps to follow in, and they set an example of not focusing on being a woman lawyer, but just being a good lawyer and treating people with respect and doing it right and practicing law with dignity. And it was a wonderful lesson to learn.
So when we have some of these younger lawyers entering the field now, women, men, but focus specifically on women, do you have any tips of the trade? Do you have any suggestions for these young attorneys getting out into the field now of who to seek out, what we should do, who to look for?
Get some help. It's tough. The days of lawyers growing up in a big firm where there's lots of opportunity to run to people that are more older or more sophisticated, more experienced, aren't there for a lot of the young lawyers, which I feel very bad for. I mean, they're missing opportunity that I took for granted when I was a young lawyer. So there's not a lawyer out there that is not willing to help. It's not an age thing. It's not even a younger lawyer. It's just a lawyer coming into this field. So ask questions, get on the phone. Don't be embarrassed to say that you don't know something. We're all there. I still get on the phone and ask questions if I come across something I don't know or haven't dealt with or need an expert in a particular field. So there's lots of help out there. Take advantage of it.
And how did you find your way from plaintiff's work into family law? Was there some sort of a point in your career where there was a transition, or how did you find your way into this sometimes difficult field?
That's a good question, because if you had ever told me that I was going to grow up to be a family lawyer, I would have argued with you. I kind of morphed into it. I had been practicing probably for 10 years, and I started getting some clients that were getting divorced, and I wanted to refer them to someone. And at that time, the family lawyers were fairly limited in scope. The family lawyers had grown up with a fault concept, and that's how they learned to practice law. And we were totally away from that by that time. So I looked around and really didn't see a lot of people that I felt comfortable referring these commercial clients to. So I just kind of gradually got my toe into it. But it's an extremely rewarding field, and I found I really liked it. I mean, it's one thing to represent, some big corporation against another big corporation, and all they're fighting about is money. And at the end of the day, really, who cares? I mean, it's kind of like, I call it like real law, but it's not rewarding. What we do in our field, we get to help people, and we really get to use our legal experience in a positive way so that people come out of what's usually their most difficult time in their life in a better place. And it's rewarding to see clients when you can make them better parents and better ex-spouses, and just get through that painful period and have them intact at the end.
And I think that's one of the reasons I got into this field, and started practicing law about 10 years ago. And I always wanted to help people and didn't want to help the big guy or the big corporation. But I found quickly that because we were dealing with people, we were able to make these great changes in their lives. But at the same time, we were dealt lots of baggage by our clients and all the drama and how they come into our office. And I found that early on, and even now, a lot of days, it's hard to kind of detach and leave that at work. So, this is not always the touchy-feely, happy stuff. And a lot of times we deal with drama. So how do you detach? How did you leave that baggage at work? What worked for you?
Well, being empathetic and still staying detached is the key. I mean, you have to care about people, or you don't need to be in family law. You can be doing tax law or anything other than family. But at the same time, we all need to accept that these are not our problems. These are the client's problems, and we do what we can to fix them. And so many of the problems are not legal. The legal problems are the arena we're dealing with, because that's really the only arena these people have. But they go far beyond that. They're the problems that led them to maybe making bad choices in spouses or mates. We have to correct ourselves. They're not all spouses anymore. There's all these underlying issues that brought them to our door. So what worked for me was recognizing them and keeping boundaries. I have a strong rule, you don't socialize with clients. You don't be Facebook friends with clients. You keep a certain boundary up that enhances your professionalism and still let you care about them, but not let you get so involved in their life that you start wearing their issues.
I think that's important, because so many of us nowadays, like you said, you're on social media, they're requesting you, or they want your cell phone and they want to text you on the weekend and all of that. So did you sort of have a policy or a way that you handled that with clients off the bat as a tip for other attorneys?
The instancy of response is a wonderful thing and an albatross all at the same time, because I find myself wanting to text clients because it's quick. I need a quick answer, or whatever. And of course, as soon as you do that, they have your cell phone number. But that doesn't mean you have to answer the phone call every time. And it doesn't mean when you get a text at 3 o'clock in the morning, you respond to it. I generally will wait till Monday morning.
After doing this for a long time, as you called it, how did you have your fun? How did you leave? We talked about leaving this baggage at the office and having that separation and recognizing it was our clients' issues, and we were the attorney. But was there a way that you unwound during all these years? How did you let yourself release from all of this stuff that we hear, this toxic stuff all day?
Well, I have a motto, you work hard, but you play even harder. And I play really hard. I've done everything from the triathlon phase and the golf phase, which I still have. And my real passion is horses. So I ride horses a lot, and I show horses a lot. And I live on an 860-acre ranch just east of Okeechobee and have a full-time job running that ranch. So I spend my non-lawyer hours are spent doing physical labor, and it works. It's a good balance.
That's your release. I love it. Every time I have horse case issues, I'm always like, Melinda's the expert in the horse stuff. So you've been board certified for a long time in marital and family law, which I think is an amazing credential on your resume. Do you have any tips for those of us who are maybe looking at that point in our career where we're thinking, like, should we take the test? Should we not take the test? Is it important, not important? Or just any tips of the trade on how to consider taking the test?
I highly recommend it if you're going to be spending any time in family law, because it's the one way that you can ensure that you will be at the cutting edge of your field. One of our obligations to our clients for going to hold ourselves out as experts in this area is to know what it is we're doing. So being board certified to me is a very important representation of your credentials. And don't be upset if you take the test and don't pass it the first time. There's many, 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 many people that don't pass it the first time. But you will learn more preparing for the test than you will probably ever learn. I know when I was studying for the exam, back in the dinosaur age, all I kept saying to myself is, oh my God, I didn't know this. I didn't know this. Because we get pigeonholed into doing certain types of case, and we can do it in our sleep. But to be board certified, you have to have a working knowledge of all other aspects of the family law arena, which involves a lot of different chapters of the statute books, a lot of the rules, a lot of the judicial administration, and all those other aspects that we don't deal with. So studying for the test will make you a better lawyer for sure. And I highly recommend it. And you should be taking the test. It's a pain in the neck, but it's worth it.
And I remember a lot of the board certification review courses where I've been up in Orlando, and you've lectured and you've talked about professionalism and just sort of being, having candor to the tribunal and to your opposing counsel and all of that. And I remember specifically you did one where you were asking questions and walking around the audience, and it was wonderful. So I find that a lot of times in this field, we meet a lot of people who don't always follow that sort of professionalism or, just doing the right thing all the time for their clients against opposing counsel. But do you have any recommendations of, how to handle when you're dealing with someone else on the other side of a case who maybe is not the most professional, or a client who puts you in a position perhaps that causes you to question if you're doing the right thing?
That's an excellent question, and I don't have any magic wand answer for you. I'm sorry. I wish I did. And two different answers. Dealing with the lawyer on the other side that's either not particularly straightforward or forthcoming, or not knowledgeable, both have equal disastrous type results, because you can't move forward in the direct straight line that you want. And it's very frustrating. And the only advice I can offer is not to get caught up in that drama and do the same thing they're doing. Stay the course. Eventually you'll get there. If you're dealing with someone difficult, don't be afraid to let a judge be what a judges do. I mean, let them make those kind of decisions. I try to avoid court at all costs, but at some point they're there. If I have to deal with a really unreasonable person on the other side versus a really well-trained judge, I'm going to let the judge be that decision maker. And then there's always the difficult client, but we can control the difficult client because we can always elect not to represent them. And I've done that. And some of the happiest days in my office is when I stop representing those difficult clients. I mean, you can feel the air of the entire staff lift, because in every practice, especially in family, but I think in every practice, there's going to be 1% of your active files that take up 90% of your time, effort, and grief.
That's so true.
When you realize that they're consuming more energy than it's worth financially or emotionally or for staff personnel, and they're not being trainable, don't be afraid to not represent them anymore. I mean, a lot of clients start out as miserable clients. They're in a miserable place of their life, but they're trainable. And that's part of the good part we do, is when we get them off the ledge and get them out of their emotional state and move them into a more business-like approach. Some are just not trainable. Recognize that and get out when you can.
I think that's so important. That's something that's taken time for a lot of us to really understand, is that just because they need the representation doesn't mean we have to do it. And you're right, it sucks the air out of your entire being and your staff. So I think that's hugely important advice. And I guess something fun we'll end on here with you. I know we were talking the other day about how we could all write books about what we do in this field every day. And by this point in your career, you're looking at encyclopedia volumes. I mean, you've had so many fun experiences. So is there a particular case or client or situation, or just, and it could be something that you learned from or something that just caught you off guard and you never made that mistake again, but is there something that really sticks out, or maybe a couple things that stick out in your mind over the years that you're like, that's going to be in the volume of my book I write someday?
Oh boy, I would really not only have to change the names, but a whole bunch of other factors are there that I'll be recognized. God, there's so many, Karen. I can't. I mean, Joel Wiseman and I went to Trinidad to take depositions in one case. That was great fun.
I'm sure.
Yeah. because they all wore the wigs like from England. So we were dealing with masters, and here's Joel, who's such a hoot, and dealing with these masters. It was just, they're very formal, and of course we're not. And it was right before it was in the drum season at the time, so we got to go play the steel drums with the locals. That was cool. I love what I do, and people are character, so it's fun.
And I think it shows, because I have never had an interaction with you since I've met you where you're not smiling and don't make me not laugh. I mean, and I appreciate that. That was something I learned from an early age, is like, if you can at least smile about it and make someone else laugh, that's hugely important. And I always appreciated and respected that in you, besides being a wealth of advice and knowledge. But that's such a cool thing to still be able to do. So
we gotta enjoy what we do. You know, the search for joy is a never-ending search. So it's there. It's always right there.
I can't thank you enough for spending some of your time with me this morning and chatting about this. And we're so excited to have you be a part of this series and talking about our heroes and trailblazers in this field. So thank you so much. I adore you and appreciate it very much.
Thanks, Karen. It's been fun. Bye.
Thank you, everybody, for tuning in to episode 4 of Stephen Squibs Monthly Case Law Update. I'd like to thank CARYN and GINA for helping me with the main production, of course, RON KAUFFMAN, MELINDA, GAMOT, CLE Albanese for great contributions. And we hope you have a great month, and we'll see you in December.
Thank you for joining us for this month's edition of Stephen Squibs Monthly Family Law CLE. We hope to see you again next month. In the meantime, do something that matters. Visit www.eddiestevens.com for more information.